Brown versus Board of Education of Topeka was the landmark 1954 Supreme Court case in which Supreme Court unanimously ruled that racial segregation of children in public schools was unconstitutional. Brown versus Board of Education was one of the cornerstones of the civil rights movement and helped establish the precedent of separate but equal was in fact not equal at all. This is One My Black History. I'm your host, Country Boy, and if this is the type of content that you enjoy, you can find more content like this at onemikehistory.com. Also, if you'd like to support the channel, you can do so on my Patreon page or my Buy Me Coffee in the description below. Please give us 5 stars on Apple Podcasts and support the YouTube channel. But without further ado, let's get started. Although the Declaration of Independence states that all men were created equal, the statement was not actually law in the United States until after the Civil War. It wasn't until the 13th in 1865, the 14th in 1868, and the 15th Amendment in 1870 that ended slavery, gave equal protections under the law, and gave African American men the right to vote that the federal government even attempted to make men actually equal. Still, African Americans were often treated very differently from whites, especially in the South. Many state legislatures began to enact laws that mandated the segregation of races. As I spoke to in previous episodes, these laws became known as Jim Crow laws. It was not until 1890 that these laws were directly challenged in the court. In 1892, an African-American man by the name of Homer Plessy refused to give his seat to a white man on a train in New Orleans, which he was required to do under the separate car law that was passed by the Louisiana legislature in 1890. Because of his actions, he was arrested. Plessy then contended that the Louisiana law separating blacks from whites on trains violated the Equal Protection Clause of the 14th Amendment of the Constitution. By 1896, the case had made its way all the way up to the United States Supreme Court. By a vote of 7-1, the Supreme Court ruled against Plessy, ruling that racially segregated public facilities were legal so long as the facilities for black people and white people were made equal. Justice Henry Billings would state that the objection of the 14th Amendment is undoubtful to enforce the equality of two races before the law. In the nature of things, it could not have been intended to abolish the distinction based on color or to endorse social as distinguished from political equality. If one race is inferior to the other socially, the Constitution of the United States cannot put them on the same plane. Basically, the 14th Amendment only applied to political and civil rights, but not social rights. The ruling created sanctioned laws barring African Americans from sharing the same buses, schools, and other public facilities as whites and establishing separate but equal as a doctrine in the United States. As a result of the Plessy decision, early in the 20th century, the Supreme Court continued to uphold the legality of Jim Crow laws and other forms of racial distinction. For instance, in 1899, in the case of Cummings versus Richmond Board of Education, the Supreme Court refused to issue an injunction preventing the school board from spending tax money on a white school when the same school board had closed a black school for financial reasons. Also, in 1926, in Garland v. Rice, the court upheld the school's decision to bar a student of Chinese descent from a white school. Despite the Supreme Court ruling in Plessy versus Ferguson and similar cases since, organizations like the NAACP continue to press for the end of Jim Crow. Beginning in the 1930s, the NAACP's Legal Defense and Education Fund began to try to make progress in overturning segregation in the courts. From 1935 to 1938, the legal arm of the NAACP devised a strategy to attack Jim Crow laws by striking them in the field of education where they perceived them to be the weakest. In 1933, the NAACP's Legal Defense Fund decided to take on the case of Donald Murray, an applicant to the University of Maryland's law school who was rejected solely because of his race. The NAACP decided to challenge this practice in the Maryland court system. So before the Baltimore City Court in 1935, NAACP lawyers argued that Donald Gaines Murray was just as qualified as any white applicant and that solely based on his race that he was rejected. Furthermore, they argued that since black law schools in which Murray could attend were nowhere near the academic caliber of the University of Maryland Law School, the disparities between white and black law schools were so great that the only remedy was to allow him to attend the University of Maryland. The Baltimore City Court agreed, and the University of Maryland appealed to the Maryland Court of Appeals, but in 1936, the Court of Appeal ruled in favor of Murray and ordered the law school to admit him. In 1936, Lloyd Gaines, a graduate of Lincoln University, applied to the University of Missouri Law School but was denied solely based on his race. The state of Missouri gave Gaines two options: to either attend an all-black law school that had not been built yet in Missouri because Missouri did not have any all-black law schools at the time, or have Missouri help pay for him to attend a law school in a neighboring state. Gaines rejected both of these options and employed the services of the NAACP's Legal Defense Fund. He decided to sue the state in order to allow him to attend the University of Missouri's law school. In 1938, his case reached the Supreme Court, and in December of that year, the court ruled with Gaines. Unlike the Murray case, which only had an impact in Maryland, the Supreme Court ruling in the Missouri case will be felt nationwide. The 6-member majority ruled since the black law school did not currently exist in the state of Missouri, the Equal Protection Clause required the state to provide within its boundaries a legal education for Gaines. In other words, since the state did not provide a legal education for white students, it could not send black students like Gaines to another state. Unfortunately, one night in 1939, Gaines left home to buy stamps and was never seen again. In 1940, the case was dismissed due to the lack of the plaintiff. During the 1950s, the NAACP felt that the time was right for a more aggressive approach. The Legal Defense Fund, the National Legal Committee, and 14 branch leaders of the NAACP came up with a plan to end racial segregation once and for all. This inaugurated a new era of NAACP litigation. There would be no more tiptoeing around Plessy v. Ferguson. The time had come to topple it completely, and it was an exceedingly ambitious goal given the state of race relations in the United States. The NAACP then encouraged African American parents to enroll their children in white school. All the parents' requests were refused, including that of Oliver Brown, the plaintiff in the case of Brown versus the Board of Education. The case originated in 1951 when the public school of Topeka, Kansas refused to enroll the daughter of a local black resident, Oliver Brown, at the school closest to her home, requiring her to travel on a bus to a segregated elementary school further away. Unlike school districts in other states, in Topeka, the lower courts ruled that while requiring certain changes, they had found that the segregated school was substantially equal with respect to buildings, transportation, curricula, and educational qualifications of the teachers. Hence, the involvement of the Kansas case in the Supreme Court's findings would hinge solely on the matter of segregation. The Browns and 12 other local families in similar situations, with the help of the NAACP, filed a class action lawsuit in the U.S. federal court system against Topeka Board of Education, alleging that the segregation policy was unconstitutional. Then Brown's case and 4 other cases, Briggs v. Elliott, Davis v. Board of Education of Prince Edward County, Bowling versus Sharp, and Gerhardt versus Ethel. While the facts in all these cases were different, all the cases were related to school segregation and first became for the Supreme Court in 1952. The court then combined all these cases under the name Brown versus the Board of Education of Topeka. Once again, the NAACP's Legal Defense Fund handled the cases, and an attorney for the plaintiff was Thurgood Marshall. On December 9, 1952, Brown versus the Board of Education was argued before the Supreme Court. Marshall stated that black students in Topeka who had attended segregated schools, even though the facilities were equal, were being denied equal educational opportunities. He would state that the Constitution did not stop with the fact that you have equal facilities and covers the entire educational process. Paul E. Wilson, the Assistant Attorney General for Kansas, based his defense on the 1896 Plessy decision. It is our theory that the case resolves itself to this: whether separate but equal doctrine is still the law. Wilson's argument put the issue squarely on the Supreme Court. The state of Kansas, he argued, was happy to do whatever the court decided, but the court had never ruled on the Plessy decision. Over the next 2 days, Briggs v. Elliott, Davis v. Board of Education of Prince Edward County, Bowling v. Sharp, and Gerhardt v. Ethel were all argued before the Supreme Court with similar arguments. At first, the justices were deeply divided. Most of them wanted to reverse Plessy and declare segregation in public schools to be unconstitutional. But Chief Justice Fred M. Venison held, in his opinion, that the Plessy verdict should stand. Unable to come to a solution, then June 8, 1953, the Supreme Court shocked the NAACP and the nation by deciding to rehear the case. The court issued 5 questions to the lawyers on either side of the case. The questions were mostly historical and designed to address whether the framers of the 14th Amendment would understood it to be inconsistent with the racial segregation of public education. More importantly, it was a delaying tactic. The 1952 election brought a new president in office, Dwight D. Eisenhower. Some members of the court felt that Eisenhower administration needed time for whatever decision the Supreme Court gave. But in September of 1953, Chief Justice Fred M. Venison would die, and President Dwight Eisenhower would replace him with Earl Warren, then governor of California. Chief Justice Warren was able to do something that Justice Venison could not. He was able to bring all the justices to agree to support a unanimous decision against school segregation. On May 17, 1954, the United States Supreme Court ruled unanimously 9-0 that racial segregation in public schools violated the 14th Amendment of the Constitution, which prohibits states from denying equal protection of laws to any person within its jurisdiction. The decision declared that separate but equal facilities for white and black students were inherently unequal, thus rejecting separate but equal doctrine in public schools. Although the 1954 decision strictly applied to public schools, it was implied that segregation was not permissible in other public facilities. While the Supreme Court ruled against separate but equal doctrine, it didn't actually explain how they would go about integrating schools. The Brown verdict outraged white segregationists as much as it energized civil rights activists throughout the South, where state constitutions and state laws mandated segregated schools. Many whites complained that the decision was a tyrannical exercise of federal power. White Americans implemented a strategy of massive resistance to desegregate or deployed tactics against the growing movement of civil rights. Segregationists used criminalizations, arrests, and imprisonment of peaceful protesters, as well as bombings and murders to prevent desegregation of schools. The origins of the massive resistance had its roots in Virginia. August 23, 1954, shortly after the Brown decision, the Gray Commission was established. It was an all-white public school commission created by Virginia Governor Thomas B. Stanley, and it was created to study the effects of the Brown versus Board education decision and make recommendations. Before its final report was issued, November 11, 1955, the Supreme Court responded to calls for immediate federally enforced desegregation with the follow-up decision known as Brown 2, directing federal district judges to implement segregation with deliberate speed. This vague command only provided for more legal challenges and loopholes, and later in 1955, the commission issued an 18-page report called the Gray Plan, which recommended several strategies aimed at slowing desegregation of public schools. All of these things caused Virginia to become the epicenter of the massive resistance, and the Brown 2 ruling was hailed as a victory for the South. The Brown 2 ruling emboldened states to undermine the court's desegregation efforts, and the decision imposed no deadlines on the beginning or the completion of integration and issued vague guidelines that granted Southern District Court judges broad discretionary oversight. In Louisiana, voters overwhelmingly approved a constitutional amendment that allowed the states to use police powers to keep a school from being integrated. And in North Carolina, devised a plan that permitted a local commission to close public schools by popular vote if they were being threatened with imminent desegregation. So by 1956, Senator Byrd of Virginia created a coalition of 100 Southern politicians to sign his Southern Manifesto, an agreement to resist the implementation of Brown versus the Board of Education. On February 25, 1956, Senator Byrd issued a call for massive resistance, accusing the Supreme Court of a clear abuse of judiciary powers and to use all lawful means to bring about its reversal. In response, they called for a series of laws that aggressively attempted to forestall or prevent schools from being integrated. For example, the massive resistance doctrine included a law that punished any public school that integrated by eliminating state funds and eventually closing the school. Legislators in 8 southern states, Alabama, Arkansas, Florida, Georgia, Louisiana, Mississippi, South Carolina, and Virginia, also enacted interposition resolutions which denounced Brown as an illegal encroachment on states' rights and declared it null and void and to have no effect. In addition to this legislative resistance, white population in the South mobilized en masse to nullify the Supreme Court decree. In states across the South, whites set up private academies to educate their children, and some counties even closed public schools altogether, as well as using those public funds to support the attendance of children in segregated facilities. That was until the use of public funds for private academies was successfully challenged in court. The massive resistance was spread beyond the opposition of simply school desegregation and would come to encompass a broad agenda in defense of racial prejudice of traditional means in the South. Some southern states would outlaw the NAACP, and after a local city council calculated a roster of NAACP members in Clarity County, South Carolina, all of those members listed promptly lost their jobs, credit, and suppliers. In 1956, Georgia incorporated the Confederate flag into its state flag, and within a few years, South Carolina and Alabama began flying the Confederate flag at their state capitals. Even President Eisenhower did not personally support the Brown versus Board ruling. He would proudly state that, "I don't believe you can change the hearts of men with laws." Because of this, virtually no segregation occurred in former Confederate states until 1957. Meanwhile, in the fall of 1957, in response to the Brown decision, African American and NAACP in Little Rock, Arkansas pressured the school board, and they adopted a gradual plan for integration of their schools. The first institution to be integrated would be the public high schools, beginning in September of 1957. Among them was Little Rock Central High School. 9 black students then registered to be the first African Americans to attend Central High School. Warned by the Little Rock School Board not to attend on the first day, the 9 black students arrived on the second day, accompanied by a small group of ministers. In addition, 270 Arkansas National Guard was sent by Arkansas Governor Orville Eugene Flaibus, blocking the school's entrance, and a large white mob gathered in front of the school and began shouting, throwing stones, and threatening to kill the students. The confrontation in Little Rock drew international attention to racism and civil rights in the United States, as well as the battle between state and federal powers. Television and newspaper reports devoted substantial coverage to the Little Rock Nine, and Dwight Eisenhower and Governor Flaibus and Little Rock's Mayor Woodrow Mann discussed the situation over the next 18 days, during which time the 9 students would stay home. The students returned to high school on September 23rd, entering through a side door. They were eventually discovered, however, and white protesters became violent, attacking African-American bystanders. The students were then sent home. Eisenhower would in turn send the 101 Airborne to Little Rock, Arkansas, and place the Arkansas National Guard under federal command to protect the students. The troops remained in Arkansas for the entire 1957-1958 school year, and after troops were withdrawn, however, Governor Flaibus closed Little Rock public high schools for the entire 1958-1959 school year. And many other states authorized the closing of public schools to attempt to avoid desegregation. In 1956, Virginia Public Assembly passed a law requiring the closure of any public schools where white and black children were enrolled together, and to cut off state funding for integrated schools. States also redirected those public funds to maintain segregated education. After Virginia's highest court invalidated the 1956 laws closing and defunding integrated schools, lawmakers enacted a freedom of choice program that created tuition grants for white students to attend the private school of their choice. Additionally, officials in Prince Edward County, Virginia, closed the entire public school system in 1959 after federal court ordered integration, and instead created private schools for white students using state grants and county tax credits to cover tuition expenses. Over 90% of the county's white students enrolled in the new all-white private schools, while more than 1,700 black students in the county had no state-funded educational option for 5 years until the Supreme Court overturned Virginia's tuition grants and forced the public schools to reopen. Federal courts struck down state efforts to selectively close public schools to avoid integration, but those rulings failed to stop white residents from fleeing public schools. By 1963, after the federal court ordered the integration of Macon County, Alabama, Governor George Wallace temporarily closed Tuskegee High School to prevent 13 black students from enrolling. When the school reopened, all 275 white students had withdrawn, and most of them used state-funded scholarships to enroll in Macon County Academy, a newly formed all-white private school. Because of this, by 1960, in the 5 Deep South states, every single one of the 1.8 million black children attended a segregated school by the fall of 1960. And by the start of the 1964-1965 school year, less than 3% of the South's African American children attended school with white students. And in Alabama, Arkansas, Mississippi, Georgia, South Carolina, that number remained lower than 1%. Meanwhile, November 1960, after state legislature attempted to block the federal court from ordering the desegregation of New Orleans schools failed, a mob organized outside 2 elementary schools where 4 black students had enrolled. Escorted by federal marshals, 6-year-old Ruby Bridges started the first grade at an all-white elementary school and was greeted with hundreds of vicious protesters spitting and yelling obscenities at first graders who had just wanted to attend their first day of school. A group of white mothers gathered daily to scream at the children, and one mother threatened to poison Ruby Bridges on her second day of school, and another presented her with a black doll and a wooden coffin. When Ruby Bridges arrived at her assigned classroom, her and her teacher were the only 2 people present. All of the white children had withdrawn from the school, and Ruby Bridges remained the only student in her classroom for the entire school year. Her family members faced threats and retaliation. The local store banned Ruby Bridges' family from entering, and Ruby Bridges' father lost his job, and her grandparents were evicted from the Mississippi farm where they worked as sharecroppers. Years after the Brown decision, up to a quarter of Southerners admitted to pollsters that they favored violence if necessary to prevent school desegregation. The White Citizens Council, which mostly consisted of middle-class white segregationists, spread rapidly throughout the South. By 1956, they had more than 250,000 members. The White Citizens Council claimed that they rejected violence, but their rhetoric suggested otherwise. A handbill circulated at a large council rally in Montgomery, Alabama, denounced segregation and declared that when the course of human events becomes necessary to abolish the Negro race, proper means should be used, among them guns, bows and arrows, slingshots, and knives. Law enforcement and white elected officials tolerated and even encouraged racial violence and terroristic acts. Many in law enforcement are members of the White Citizens Council or the Ku Klux Klan, and all-white juries consistently acquitted those charged with violence against black people and effectively immunizing perpetrators of racial violence from punishment. After the murder of Mississippi civil rights activist Vernon Dahmer, Klansman Sam Bowers boasted that after being indicted for that murder, that no jury would convict a white man killing a nigger in Mississippi. And he was right. He wasn't convicted until 1998. By 1967, a report in the U.S. Commission for Civil Rights observed that violence against Negroes continues to be a major deterrent in school desegregation. 14 years after Brown versus the Board of Education, the massive resistance will meet a formal end for Supreme Court ruling in Green v. County School Board of Kent County, which deemed that nearly all segregationist tactics were in violation of federal law. The Supreme Court held that the freedom of choice plan, which allowed students to pick the school that they wanted to attend, was not a sufficient step in the desegregation of public schools. While the freedom of choice plan may work in some situations, school districts must provide a plan that works to dismantle school segregation in their district. The massive resistance and its aftermath left a deep, long-lasting negative imprint on public schools by delaying the effective desegregation into the late 60s. Despite its best efforts, many parts of the American South continued to see white backlash against desegregation. It took the form of lawsuits, school closures, evictions of black families, procedural delays, and physical blockades and mob violence. This provided time for substantial numbers of white students to withdraw into privately, usually white-only academies. It was not until the Legal Defense Fund's victories in Green versus County School Board and Swan versus Mecklenburg County that the Supreme Court issued mandates that segregation must be dismantled, root and branch. In these rulings, the court outlined specific factors that must be considered in elimination of the effects of segregation and ensured that the federal court was able to exercise its judicial authority in desegregation. Thank you. This has been One Mic Black History. I'm your host, Country Boy, and this has been The Massive Resistance. If you like stories like this, you can find more stories like this at onemichistory.com. Also, if you want to support the channel, you can do so on my Buy Me Coffee and Patreon page in the description below. Also, give us 5 stars on Apple Podcasts and support the YouTube channel. Peace.